untouched. Therefore, I counsel people all the time when we're getting divorced, don't sign a property settlement agreement agreeing to pay a debt if you're going to file bankruptcy, because you're going to be stuck with the debt. Maybe Citibank can't sue you, but your husband or wife can. And then you'll have to pay through the back door, which you don't have to pay through the front door. So if you've got a domestic situation and a financial situation going on, you might want to talk to an attorney before signing anything to make sure you're not binding yourself to something in your domestic situation that's going to be harmful to you to try to get a fresh start in bankruptcy later. So that's really important. Husbands and wives, if you're married, you don't have to both file. One of you can file, the other one doesn't have to. Sometimes both parties don't want to file, other times it's to protect property, or only one party is on a certain debt and the other one isn't. Could even be a debt from a prior, before they got married, a prior time. So there's no requirement that both file. Each person is considered having the right to file bankruptcy. You can file a Chapter 7 bankruptcy every 8 years. Now a Chapter 7 bankruptcy is called a liquidation. You file it, you list all your assets, you list all your debts. At the end of the 90 to 100 days, you get a fresh start, you're done. Chapter 13 is for people who make too much money to file a 7. You have so much money that you can pay all of your bills and still have money left over for your creditors. Not a lot of people that meet that criteria. But if that was the case, you would file a 13, you would make payments into the court of whatever you could afford for 5 years, and at the end of that time, any remaining debt would be discharged, and you would start over at that point. We see very few Chapter 13s. Every now and then we get someone, but you really have to make enough to pay all your bills plus some, and for most people, that just isn't happening. I'll talk a little bit about
So we talked a little bit about your creditors not being able to contact you during the pendency of a bankruptcy, and that extends in some pretty beneficial ways to the debtor into some other areas. A lot of you may have been to a hearing on a warrant of debt or had a judgment entered against you, and you hear creditors threaten garnishments or levies or attachment all the time. The mandatory federal stay that's put in place by the court during every bankruptcy stops those collection efforts, including garnishments, in their tracks. As soon as the bankruptcy case is filed and the creditor and your employer have notice, or the creditor and the bank have notice, those garnishments have to stop. What you do on your petition is we end up listing the garnished wages, however much has been garnished up to the date that you filed, list them as an asset on the bankruptcy petition, and you protect it under one of the exemptions that Virginia allows you. And at that point, the garnishment will stop. Obviously, if you keep working with your employer, you'll continue to receive your normal paycheck with the garnishment not being taken out. So that can be very helpful to people who then obviously don't have to continue making those other payments to credit cards and that sort of stuff. It's very helpful to them to kind of get back on their feet budget-wise. And then at your 341 hearing, typically what ends up happening is the creditor or your employer, whoever has been holding the money, sends it to the trustee. This is what happens in most cases. It ends up with the trustee at your 341 hearing, and he hands us a check and says, this is the garnished wages. As long as you've exempted it, here you go, guys. This is your check, and here's your funds back. Under certain circumstances, maybe the creditor or the employer doesn't send it back right away, and then generally it's just a matter of doing the footwork to try to get that back from the creditor or the employer. At any rate, at some point it comes back to you. Now this extends to not only the wages that were being garnished at the time that you filed, but also if there was a garnishment pending, right, so the creditor is taking money away from your paycheck. I don't know if you guys have seen a garnishment summons recently, but the way it works is you put the garnishment down, it lists who the money is supposed to go to, and then in the top right corner it has a date. It says May 12th or whatever. That's the date on which those funds are going to be turned over to the creditor. Okay? Any funds that have been turned over to the creditor within the 90 days before you file bankruptcy are fair game. So let's say you were to file bankruptcy today. Then any funds that were turned over, let's say you have a date, a garnishment summons return date in March, if it was $3,000 in March, even if it's already been turned over to the creditor, that money would essentially be a part of your bankruptcy estate and returnable to you under the bankruptcy laws. So the garnishments generally, as long as they're reasonably close to the date when you file, are going to come back to you. Okay? And then the garnishments also stop as of the date you file bankruptcy.
Another thing that Tom and I see all the time is creditors who make threats that are inappropriate. They threaten that you're going to go to jail if you don't pay their money. They threaten that they're going to take money out of your bank account or out of your wages, and they haven't sued you yet. These kind of things are illegal statements for creditors to make. There is no debtor's prison. You don't go to jail for owing money. The only possible way you can get in trouble in a lawsuit, a civil lawsuit for not paying money, is if they sue you. They get a judgment. They issue debtors interrogatories to come to court and answer questions. You're served. The judge orders you to come, and you defy the judge and you don't come. But that would be contempt of court, which could be punished by jail time. Not because you owe the money, but because you thumbed your nose at the judge and said, I don't care if you ordered me to come, I'm not coming. So a whole different circumstance. Creditors can generally do nothing but take you to court, get a judgment, and then if you work and you have wages above the minimum wage, they can garnish some of your wages, or they can try to attach a bank account. A judgment also attaches against real estate, and there is one aspect of bankruptcy that a lot of people don't know, but it's like a second mortgage. The minute a judgment hits the books, it glops onto your real estate if you own it, like a mortgage, and even if you file bankruptcy, if you ever sell your house, they can get their money plus their interest. You can't get rid of it. Well, occasionally there's ways in bankruptcy to get rid of it, but it's kind of very narrow loopholes. And it stays in the book for 20 years, so even after your bankruptcy, if you ever buy real estate, it can still attach against your house. So there's ways that you can learn to own real estate in the future if you have that problem where you won't have that problem. You could avoid it. You could buy it with a husband, in the names of a husband and wife, or you could buy it in the names of a trust or an estate, or there's other ways you can own property, or if you're worried about a judgment, or you can make a deal in the future with them, take the small amount of money and go away, because it's already been discharged in bankruptcy.